During the subsisting of the first marriage, he married second respondent herein. I have well settled law that once the matter is posted for judgment, sufficient opportunity granted to them, and they did not avail the opportunity.
In a matter of, in these matrimonial matters,
Please,
what will you do with that order?
I am jointly contesting the matter, stating
What is his stand?
that the second.
Never married you.
No. Yeah. Yes. No. He says that they were in live-in relationship. In spite of producing the registered marriage certificate, they say it is fabricated.
No,
Please.
Then the judgment will be passed.
Please.
They'll come before this court.
Please.
Now it will be here for another 5 years.
Please.
After that, now it will be set aside and remanded.
Please.
Unnecessarily, why the delay?
That is by the wife, my lords, for a divorce against the respondent number one husband. The main ground for seeking divorce is that during the subsisting of the first marriage, he married second respondent herein. I have produced the photographs of the marriage. And first marriage.
So what is the impugned order?
Please, impugned order is that, my lord, is page number 48. My lords,
Page
just
number?
48, annexure F. Just before that, your lordship. Now, this is the order wherein the trial court, after issuing the notice on the divorce petition, husband, first respondent and his second wife appeared before the court, engaged the counsel. Matter was referred to mediation. Mediation was failed. My lord, thereafter he appeared one or twice and they requested the court for filing objections. Court has granted them a time up to more than 1 year, 2 months for filing objections. Ultimately, when even after last chance, they did not file objection, court passed an order stating that objection is taken as nil. Thereafter, proceedings went on. Evidence of the petitioner recorded. There also, he did not appear. And the matter was also, my lord, posted for arguments. There also, he did not appear. Ultimately, court, after, my lord, conclusion of the entire trial, my lord, on 19/2/24, posted the matter for judgment. On 26/2/2024, on 26/2/2024, the respondents 1 and 2 appear before the court, file 2 applications. One is for permission to file written statement. Another one is to recall the witness. These applications was contested by the petitioner, mainly on the ground that it is well settled law that once the matter is posted for judgment, sufficient opportunity granted to them, and they did not avail the opportunity.
In a matter of, in these matrimonial matters,
Please.
what will you do with that order? What will you do with the order by obtaining an order?
Ultimately, court will
It
have.
is a contested matter. It would then the court will dispose it of now. Will say that without granting further adjournments, that the matter be decided. Now, what will happen? Now, an order will be passed against that.
No.
No.
Please.
Then the judgment will be passed.
Please.
They'll come before this court.
Please.
Now it will be here for another 5 years.
Please.
After that, now it will be set aside and remanded.
Please.
Unnecessarily, why the delay?
That situation, irrespective of whether it is contested or non-contested, that will continue to be up to Supreme.
It will be. No,
irrespective of whether he is contested or uncontested.
No. You will have another 5 years addition to this.
Yes, my lord. That position never changes, even if this application is allowed also, because it is not ex parte order.
It will
He
not
appeared-
change. It will add for what is a regular litigation. Another 5 years will add, because once they question it
Please.
before this court,
Please.
5 years, 6 years, it will be pending. At the time of final hearing, the order will be set aside and matter will be remanded to the trial court. Then again, your timeline starts from there.
My submission is based on the settled portion of law laid down by the division bench of this court as well as the Supreme Court, that once the matter is posted for judgment, no applications has to application.
Court has the 2000 causes, some costs are imposed.
Lord, the opportunity which is granted was not availed, and no reasons filed, in the affidavit for not contest.
For you.
Pardon?
What is the MC filed by you?
Divorce me. Please.
He is already married.
He is already married. Second marriage, and I have produced the photographs. He disowned the petitioner and first marriage, and my lord, he has begetted the children out of the second marriage, and both of them now jointly contesting the matter, stating.
What is his stand?
That the second.
Never married you.
No. Yes, no. He says that they were in live-in relationship. in spite of producing the registered marriage certificate, they say it is fabricated. That is fabricated.
What is the reason stated for not contesting the matter?
No reasons assigned at all. I have produced the
Where is
affidavit.
the petition?
Affidavit.
There,
Affidavit accompanying the application. Lord, at page number. Lord.
that's an
Page
important
number
issue.
35, Lords.
That's an important issue. He says that you're not his wife. That's an issue to be decided by the court.
But my lord, the law which has been laid down that once a matter is posted for judgment, I am entitled for the benefit
There are
of the law
there
declared.
are so many other judgments also. Several times when the matter is posted for judgment also, the courts have passed
No,
orders.
my lord, absolutely. The High Court division bench of this High Court and Supreme clearly held that once the matter is posted for judgment, no applications are maintainable. Court has to proceed to pronounce it. May I, my lord, pass on the judgment? Two judgments of this Honorable Court and the Supreme Court.
What are the facts of that case?
Lord, there also, my lord, opportunities granted, they did not avail it. So when the person who is not
Matrimonial
vigilant,
proceedings?
plus,
Matrimonial proceedings?
no, not matrimonial. In some,
That's the point.
in respect of
That's the
some other
point.
context.
That's the point.
Some other context.
That's the point. We'll ask the court without
No
granting-
reasons, not.
without granting further
Lord,
adjournments.
my respectful submission, my respectful submission is the husband has granted more than my lord, 1.5 years time.
MC is 2022.
Lord, kindly appreciate the
There are MC petitions that are pending from the last 10 years, 7 years, 8
Lord,
years.
that is not the my lord. I am not my lord on the point. My point is a person who is not vigilant in conducting the proceedings and he mutely, my lord,
Even if you have come before the court also, order would have been the same. No, there should be let's not go on these technicalities. And that too in a particular facts of the case where he denies that you are the wife. When there is no marriage, where is the question of divorce?
my lord, I have produced, my lord, but
That's your case. Yes.
I have produced the marriage certificate.
No, we'll say that will not let the court without granting much adjournment shall proceed with the matter. And shall pass an order.
Lord, may I Lord, in the month of February, Lord, court has to pronounce the judgment on 26/2/2024. Lord, they want, their intention is to drag on this matter for the mainly reason that
That's why we'll fix a timeline.
3 months.
6 months.
No, here what happened? I mean, from my side, evidence, everything is over.
First of all, otherwise this is a 2022 matter. Generally, this court is not passing any orders. Considering these facts of the case, court is saying 6 months. 3 months is a very short time. Court has other matters to attend. Please come. This court, having heard the learned counsel for the petitioner, had perused the material placed before the court. The parties are, the case of the respondent is that he has not married the petitioner. They were in a live-in relationship and he had married the respondent. The reason that is stated is his father expired. As such, he could not give instructions. There is no dispute about the legal portion as enunciated by this court and the Honorable Apex Court. When it comes to the facts and circumstances of this case, where the wife seeks divorce, saying that there is a marriage between the petitioner and the respondent comes up with an objection that he is not that the petitioner is not his wife. And these are all in the light of these respective stands taken by the parties, unless and until there is an adjudication on the merits of it. It is not in the interest of either of the parties. The judgment that he is relying on or not arising out of the matrimonial proceedings. And it would be the endeavor of the court to put an end to the litigation. In that view of the matter, this court finds no reason to interfere with the order. The husband, the MC is filed in the year 2022 and it is posted for judgment on 19/2/2024. Now the matter is directed to be listed for the cross-examination on
2/9/2024. Monday.
Huh?
Monday. 2/9/24 is the next date.
2/9/2024. In that view of the matter, this court deems it appropriate to dispose of this writ petition directing the trial court to dispose of the main MC itself within as expeditiously as possible, but not later than 6 months from the date of receipt of the copy of the order. The trial court shall not grant any adjournments, unnecessary adjournments. Next para. This court is not proposing to issue notice to the respondent as no adverse orders were passed by the court, and disposal of the case is in the interest of both the parties.